Swayam Prabha. Digital India. Educated India.
योगः कर्मसु कौशलम्.
Script 27 Offences and SAT. Dear viewers, I am CS Dr.Yashree Dixit. In today's session, I am going to discuss the offences, establishment of special courts, appeals, procedure and powers of Securities Appellate Tribunal, and SEBI Depositories and Participants Regulations 1996. So viewers, by the end of this session, you would be able to understand number 1, to understand about the offences, number 2, to know about the establishment of special courts, number 3, to know about the various appeals, number 4, to understand the procedure and powers of Securities Appellate Tribunal, number 5, to understand about SEBI Depositories and Participants Regulations 1996. Now, let's discuss about the offences. Section 20 provides that without prejudice to any award of penalty by the adjudicating officer under this Act, if any person contravenes or attempts to contravene or abets the contravention of the provisions of this Act or of any rules or regulations or bylaws made thereunder, he shall be punishable with imprisonment for a term which may extend to 10 years or with fine which may extend to 25 crores rupees or with both. If any person fails to pay the penalty imposed by the adjudicating officer or fails to comply with any of his directions or orders, he shall be punishable with imprisonment for a term which shall not be less than 1 month but which may extend to 10 years or with fine which may extend to 25 crore rupees or with both. Now we will discuss offences by companies. Section 21 provides that where an offence under this Act has been committed by a company, every person who at the time the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. The proviso to the section also provides that nothing contained in this subsection shall render any such person liable to any punishment provided in this Act if he proves that the offence was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence. Where an offence under this Act has been committed by a company and it is proved that the offence has been committed with the consent or convenience of or is attributable to any negligence on the part of any director, manager, secretary or other officer of the company, such director, manager, secretary or other officer shall also be deemed to be guilty of an offence and shall be liable to be proceeded against and punished accordingly. Now we will discuss cognizance of offences by courts. Section 22 provides that no court shall take cognizance of any offence punishable under this Act or any rules or regulations or bylaws made thereunder except on a complaint made by the central government or a state government or the SEBI or any person. Composition of certain offences. Section 22A provides that notwithstanding anything contained in the Code of Criminal Procedure 1973, any offence punishable under this Act not being an offence punishable with imprisonment only or with imprisonment and also with fine may either before or after the institutions of any proceeding be compounded by a securities appellate tribunal or a court before which such proceedings are pending. Establishment of special courts. Section 22C provides that the central government may, for the purpose of providing speedy trial of offences under this Act, by notification establish or designate as many special courts as may be necessary. A special court shall consist of a single judge who shall be appointed by the central government with the concurrence of the Chief Justice of the High Court, within whose jurisdiction the judge to be appointed is working. A person shall not be qualified for appointment as a judge of a special court unless he is immediately before such appointment holding the office of a sessions judge or an additional session judge as the case may be. Offences triable by a special courts. Section 22D provides that all offences under this Act committed shall be taken cognizance of and triable by the special court established for the area in which the offence is committed, or where there are more special courts than one for such area, by such one of them as may be specified in this behalf by the High Court concerned. Appeal and revisions. Section 22E authorizes the High Court to exercise so far as may be applicable all the powers conferred by Chapter 12 and 13 of the Code of Criminal Procedure 1973 on a High Court as if a special court within the local limits of the jurisdiction of the High Court, where a court of session trying cases within the local limits of the jurisdictions of the High Court. Application of a court to proceedings before special court. Section 22 lays down that the provisions of the Code of Criminal Procedure 1973 shall apply to the proceedings before a special court, and for the purpose of the said provisions, the special court shall be deemed to be a court of a session, and the person conducting prosecution before a special court shall be deemed to be a public prosecutor within the meaning of a clause U of Section 2 of the Code of Criminal Procedure 1973. The person conducting prosecution under this section should have been in a practice as an advocate for not less than 7 years, or should have held a post for a period of not less than 7 years under the union or a state requiring special knowledge of law. Transitional provisions. Section 22G stipulates that any offence committed under this Act which is triable by a special court shall, until a special court is established, be taken cognizance of and tried by a court of a session exercising jurisdictions over the area, notwithstanding anything contained in the Code of Criminal Procedure 1973. However, nothing contained in this section shall affect the powers of the High Court under Section 407 of the Code to transfer any case or a class of cases taken cognizance by a court of session under this section. Now we'll discuss about appeals. Section 23 deals with the appeals to central government. Any person aggrieved by an order of SEBI under this Act or the regulations made thereunder may prefer an appeal to the central government within a such time as may be prescribed. No appeal shall be admitted if it is preferred after the expiry of the period prescribed therefor. However, the appeal may be admitted after the expiry of the period prescribed therefor if the appellant satisfies the central government that he had sufficient cause for not preferring the appeals within the prescribed period. Every appeal made under this section shall be made in such a form and shall be accompanied by a copy of the order appealed against by such fees as may be prescribed. The procedure for disposing of an appeal shall be such as may be prescribed. However, before disposing of an appeal, the appellant shall be given a reasonable opportunity of being heard. Appeal to Securities Appellate Tribunal. Section 23A provides that any person aggrieved by an order of SEBI under this Act or the regulations made thereunder, or an order made by an adjudicating officer under this Act, may prefer an appeal to a Securities Appellate Tribunal having jurisdictions in the matter. Every appeal shall be filed within a period of 45 days from the date on which a copy of the order made by SEBI is received by the person, and it shall be in such a form and be accompanied by such fees as may be prescribed. However, the Securities Appellate Tribunal may entertain an appeal after the expiry of the said period of 45 days if it is satisfied that there was a sufficient cause for not filing it within that period. On receipt of an appeal, the Securities Appellate Tribunal may, after giving the parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying or setting aside the order appealed against. The Securities Appellate Tribunal shall send a copy of every order made by it to SEBI and parties to the appeal. The appeal filed before the Securities Appellate Tribunal shall be dealt with by it as expeditiously as possible, and endeavour shall be made by it to dispose of the appeal finally within 6 months from the date of receipt of the appeal. Next, we will discuss procedure and powers of Securities Appellate Tribunal. Section 23B provides that the Securities Appellate Tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice and subject to the other provisions of this Act and of any rules. The Securities Appellate Tribunal shall have powers to regulate their own procedure, including the places at which they shall have their sittings. The Securities Appellate Tribunal shall have, for the purpose of discharging their functions under this Act, the same powers as are vested in a civil court under the Code of Civil Procedure 1908 while trying a suit in respect of the following matters, namely, number A, summoning and enforcing the attendance of any person and examining him on an oath. Number B, requiring the discovery and production of documents. Number C, receiving evidence on affidavits. Number D, issuing commissions for the examination of a witnesses or a documents. Number E, reviewing its decisions. F, dismissing an application for a default or deciding it ex parte. Number G, setting aside any order of dismissal of any application for a default or any order passed by it ex parte. And H, any other matter which may be prescribed. Every proceeding before the Securities Appellate Tribunal shall be deemed to be a judicial proceedings within the meaning of Section 193 and 228 and for the purpose of Section 196 of the Indian Penal Code, and the Securities Appellate Tribunal shall have been deemed to be a civil court for all the purpose of Section 195 and Chapter 14 of the Code of Criminal Procedure 1973. Next, we will discuss right to legal representation. Section 23C provides that the appellant may either appear in a person or authorize one or more chartered accountants or a company secretaries or a cost accountants in a practice or legal practitioners or any of its officers to present its case before the Securities Appellate Tribunal. Limitations. Section 23D provides that the provisions of the Limitations Act 1963 shall as far as may be apply to an appeal made to a Securities Appellate Tribunal. Civil court not to have a jurisdiction. Section 23E provides that no civil court shall have a jurisdiction to entertain any suit or a proceeding in respect of any matter which a Securities Appellate Tribunal is empowered by or under this Act to determine, and no jurisdiction can be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this Act. Next, we will discuss about appeal to Supreme Court. Section 23F provides that any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to the Supreme Court within 60 days from the date of communication of the decision on order of the Securities Appellate Tribunal to him on any question of law arising out of such order. However, that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 60 days. Areas on which rules may be framed by the central government. The central government under section 24 may frame rules to provide inter alia for the manner of inquiry under section 19H1, the time within which appeal may be preferred from the orders of SEBI under section 23 subsection 1, the form in which an appeal may be preferred and the fees payable in respect of such appeal. The procedure for disposing of an appeal, the form in which an appeal may be filed before the Securities Appellate Tribunal under section 23A and the fees payable in respect of such appeals. SEBI Depositories and Participants Regulations 1996. The Depositories Act requires the registration of the depository, depository participants and the custodian is mandatory with the SEBI. This market intermediaries can function or commence business only after registration from SEBI has been obtained and requisite fees paid to SEBI. The requirement of registration is a continuing one and the amount of registration is a cancel or revoke or surrender, the person shall cease to act as such. SEBI had issued SEBI Depositories and Participants Regulations 1996 on 16th May 1996, which apply to depositories and its participants. These regulations also contain provisions for operations and functioning of depositories, form for application and certificates used and schedule of fees for participants, etc. It also contains a provision for registration of depository and depository participants, rights and obligations of various users, and constitutes inspections and procedure for action in case of default. Entities desiring to become depository participants must apply to the depository and are required to be recommended to the SEBI by the depository. If approved and registered by SEBI, the depository participant can be admitted on the depository. The depository has to formulate its own set of criteria for a selection of participants. Every participant holding a certificate is required at all times to abide by the specified code of conduct. The regulations require the depository to list out through its bylaws the securities which are eligible to be admitted to the depository for dematerialization. Equity shares, debentures, warrants, bonds, units of a mutual funds, etc. are a part of the list of eligible securities. The depository is empowered to set its own criteria for a selection of securities and make securities eligible to be maintained in the form of electronic holding on the depository. Further, the regulation stipulates that agreements should be entered into by the following entities: depository and every participant and every client, and depository, issuer company and the register. The draft of these agreements are to be included in the bylaws and to be approved by SEBI. The depository is required to ensure that the sufficient safeguards are in place to protect the data available with it and with the participants to reduce risk in operation. The regulation stipulates the adequate insurance cover be provided by the depositories and by the depository participants as well. The regulations also require for reconciliation to be carried out on a daily basis. Further, the depositories and the register will also reconcile balances on a daily and a periodic basis. Rights and obligations of depositories and its constituents. These regulations deal with rights and obligations of depositories. Every depository has to state in its bylaws the eligible securities for dematerialization, which include shares, scrips, stocks, bonds, debentures, stock, Indian depository receipts or other marketable securities of a like nature, etc., and include units of a mutual funds, rights under collective investment schemes and venture capital funds, commercial paper, certificate of deposit, securitized debt, money market instruments, government securities and even unlisted securities. every depository is required to enter into an agreement with the issuer in respect of a securities disclosed as eligible to be held in a demat form. No agreement is required to be entered into where the depository itself is an issuer of securities. However, no such agreement shall be required to be entered into where the state or the central government is the issuer of a government securities. The depository is also required to enter into a three-party agreement with the issuer, its a transfer agent, and itself where the company has appointed a transfer agent. Every depository is required to maintain continuous connectivity with issuers, registrars and transfer agents, participants and clearinghouse or a clearing corporation. Depositories should take adequate measures including insurance to protect the interest of the beneficial owners. Every depository is required to maintain the following records and documents, namely records of a securities dematerialization and rematerialize, the names of the transferor, transferee and the dates of the transfer of securities, a register and an index of beneficial owners, details of holding of the securities of the beneficial owners as at the end of each day. Records of instruction received from and sent to participants, issuers, issuer agents and beneficial owners. Records of approval, notice, entry and cancellation of pledge or hypothecation as the case may be. Details of a participants, details of securities declared to be eligible for a dematerialization in the depository and such other records as may be specified by SEBI for carrying on the activities as a depository. Every depository has to intimate SEBI the place where the records and the documents are maintained. Subject to the provision of any other law, the depository shall preserve records and documents for a minimum period of 5 years. Participants are required to enter into an agreement with beneficial owners. It is required that separate accounts are to be opened by every participant in the name of each of the beneficial owner, and the securities of each beneficial owners are to be segregated and shall not be mixed up with the securities of other beneficial owners or with the participants' own securities. The participants are obliged to reconcile the records with every depository on a daily basis. Participants are required to maintain the following records for a period of 5 years. Records of all transactions entered into with a depository and with a beneficial owner. Details of security dematerialized, rematerialized on behalf of the beneficial owners with whom it has entered into an agreement. Records of instruction received from beneficial owners, statements of accounts provided to beneficial owners, and records of approvals, notice, entry and cancellation of pledge or hypothecation as the case may be. So friends, let us summarize the session. We discuss number 1. Section 22 provides that no court shall take cognizance of any offence punishable under this Act or any rules or regulations or bylaws made thereunder except on a complaint made by the central government or a state government or the SEBI or by any person. Number 2. The Depositories Act required that the registrations of the depository, depository participant and the custodian is mandatory with the SEBI. This market intermediaries can function or commence business only after registration from a SEBI has been obtained and requisite fees paid to SEBI. Number 3. Every depository has to intimate SEBI the place where the records and the documents are maintained. I hope this session would have made your concept of offences, establishment of a special courts, appeals, procedure and powers of Securities Appellate Tribunal and SEBI Depositories and Participants Regulations 1996 very clear. I hope you have enjoyed this session. Thank you.